I'm Bill Morris, an attorney practicing in Marco Island, Florida. I'm going to talk with you today about lawsuits and what damages are available in different kinds of lawsuits. There are three basic types of lawsuits in the state of Florida: breach of contract, torts, and those created by the legislature by statute. Let's talk about breach of contract first. In breach of contract, the goal of the courts is to place the non-breaching party in the position that party would be had the contract been performed. What does that mean for damages? Well, it basically limits the financial damages to the difference between what the buyer would have to pay and what the buyer actually pays for the substitute performance, or what the seller was going to receive and what the seller actually receives because the seller had to sell something cheaper than in the original contract. Does that mean that's all the damages that anyone gets? Not necessarily. If damages could be seen as normally expected to come from a breach of that type of contract, they might also be added on to what one of the parties can recover. Breach of a real estate sales contract is a good example. If a seller has a buyer and the buyer defaults, the seller then needs to sell the property to someone else. If it takes months before that second sale, the seller has a lot of expense taking care of the property until the second sale. If the seller sells for less than the original contract price, not only does the seller get less money, which the seller can sue the buyer for, but the seller also has those other expenses: insurance, mortgage, property taxes, lawn mowing, pool, pest control, and all of those would naturally be expected to be paid by a seller when the buyer doesn't close as required. So those are the damages that you get in a breach of contract. Can the non-defaulting party get his or her attorney's fees? Only if the contract provides for attorney's fees. If the contract doesn't provide for attorney's fees, then fees are not usually recoverable. Of course, there are always exceptions to every rule, and there could be a statute that's on point, but in most contract cases, attorney's fees are only in play if the contract provides for the winner gets attorney's fees. Now, what about torts? Torts are generally all the other cases that might be filed, all the other types of claims other than breach of contract. The most common and frequently pursued is a claim for negligence. That would be an automobile accident, a slip and fall in some business, or a similar type of a lawsuit. The damages in a tort case are similar to breach of contract. They're to place the injured party in the position that party would be had it not been for the negligence that caused their injury. However, unlike breach of contract, the injured party not only gets the medical expenses they incurred, but they get other damages such as pain and suffering, loss of enjoyment of life, any pain for what they can't do, the actual pain that they have. Those damages aren't recoverable in a breach of contract, but they are recoverable in tort cases and usually exceed even the medical damages. Now, are attorney's fees recoverable in tort cases? Not usually. Therefore, when there's a lawsuit over some type of negligence or a tort, it's careful to look at the amount of damages, because if the damages aren't significant, it's probably not worth paying a lot of money to an attorney to pursue the case. When the damages are significant enough, most attorneys take those cases on a percentage fee basis. Third types of lawsuits in Florida, damages are sought, are those created by the legislature. In some cases, the legislature believes a special cause of action needs to be created, or in others, there needs to be a real disincentive for someone to do something that's wrong. A good example for both is the legislature adopted statutes dealing with writing a bad check. When someone writes a bad check, the recipient can sue them for 3 times the amount of the check, plus the amount of the check, plus attorney's fees, all as authorized by statute. There are some conditions that have to be met before pursuing that lawsuit, but if the conditions are met, and they're very simple, a 30-day notice to the person who wrote the bad check, then the person who received the check can pursue that claim, and it is for a lot more than what you expect to be normal contract damages, which in that case would be suing the writer for the amount of the check. Well, that's a brief summary of the damages and types of cases you can pursue in Florida courts. If you have any questions, please get in touch with me.